So the Nicholas Sandmann defamation lawsuit against the Washington Post has been reinstated in part after being dismissed in whole. Now I know this is great news for Nicholas Sandmann, but when you really think about it, it's even better news for me. You know why? Vindication!
Vindication! Oh yeah, baby! Oh gosh.
Viva Frei, Montreal litigator turned YouTuber. I do these things called vlogs, and I suspect you all know what they are by now, which is why you're here. Nicholas Sandmann news update. The lawsuit for defamation against the Washington Post, which was dismissed in its entirety, has been reinstated in part. Now this situation is fascinating for a number of reasons. I have been following the Nicholas Sandmann situation from the very beginning. I've done at the very least a half dozen videos on the subject. I'll post a Nicholas Sandmann lawsuit playlist right here. In one vlog, I broke down and explained Nicholas Sandmann's lawsuit against CNN. In another vlog, I broke down and explained the Washington Post's motion to dismiss of Nicholas Sandmann's lawsuit against them for defamation. And for those of you who haven't seen that video, suffice to say I was somewhat critical of the motion to dismiss drafted and filed by the Washington Post. So much so that I said I would eat my shorts if that motion to dismiss were granted. Basically, this motion to dismiss seeks the premature dismissal before any hearing on the merits, before any witnesses have been heard. It seeks the dismissal of the suit and the preclusion of the plaintiff from ever suing on the same or similar basis again. Chances of that happening? I will eat my torn Tommy John underwear. How's that? Well, lo and behold, much to my shock and dismay, I later had to eat my shorts because the motion to dismiss was granted. And I thoroughly disagreed with the judgment granting the motion to dismiss, and not as a question of pride or being right versus wrong, just because I thought it was wrong in law. And there were diverging opinions on whether or not I was right, and another YouTube lawyer named Nate Brody in fact made a video explaining why I was wrong in my assessment of the Washington Post motion to dismiss. So apparently there's another YouTube lawyer out there and he wants to call me out on my analysis of the Nicholas Sandmann judgment?
And one of my favorite YouTubers, Viva Frei, did some great videos about the case, but I'm going to tell you something. His analysis was wrong.
Well, Nate, who's right now?
Who's right now, Nate?
I am. Okay, I'm joking.
But I am.
And for the last little while, I was actually wondering what was going on between Nicholas Sandmann and the Washington Post, because to me it seemed somewhat inconceivable that they would just roll over and give up after the motion to dismiss were granted. I didn't know if an appeal had been filed, but recently I became aware of the fact that Nicholas Sandmann had filed what is called a motion for review or a motion for reconsideration. And don't hold me to the terms because I might actually be making terminological mistakes here. All that I know is the distinction in law between what was filed, that being a motion for reconsideration or a motion for review, and an appeal in and of itself. We have something similar under Quebec law where if you feel a judge made a clerical mistake or overlooked something, you can ask them to review and make a clerical correction to a judgment. But from what I understand and from what has been explained to me, a motion for reconsideration is somewhat more substantive. You in fact go back to the judge who rendered the decision and ask them to reconsider the decision in virtue of certain mistakes in law that they have made. It is less formal than an appeal, and unlike an appeal, it is not submitted to different judges for consideration. And in fact, you can proceed by way of motion to reconsider before in fact going by way of appeal. In a way, you're basically saying to the judge, look, we're going to take this decision to appeal, but here is your last chance to get it right before we go to appeal to have this overturned and embarrass you on the juridical stage. That being said, from what I'm told, they are rarely granted because you're basically asking the same judge to reconsider the judgment that they just rendered. But lo and behold, Nicholas Sandmann filed a motion to reconsider before the same judge who granted the Washington Post's motion to dismiss, thusly dismissing Nicholas Sandmann's lawsuit against them. He asked the judge to reconsider the judge's own decision, and the judge did in fact reconsider at the very least on 3 elements of Nicholas Sandmann's claim. While the judge reiterated his conclusions to dismiss the claim as relates to the bulk of the allegations, he nonetheless reconsidered on 3 specific elements and ordered the matter to proceed to discovery. Oh my goodness, can you imagine what that discovery is going to look like? I cannot wait to analyze that discovery. And it seems that along with the motion for reconsideration, Nicholas Sandmann also filed an amended statement of claim. And I like to think that we actually had an impact on the world, but it seems from the judgment that the amended statement of claim specifically responds to certain comments that were raised in the comment section of my video reacting to the dismissal of Nicholas Sandmann's lawsuit against the Washington Post. I'll flash a few of those comments now, but a ton of people were commenting on the fact that Nicholas Sandmann's face was posted on the front page of the Washington Post's article, so even if the article itself did not specifically refer to Nicholas Sandmann, based on the association between his face being front and center on the article and the article itself, people could make the association that the article was of and about Nicholas Sandmann. And it seems from the judgment reinstating a portion of Nicholas Sandmann's claim that this allegation was added to the amended statement of claim and was determinate in the judge in reversing or reinstating certain aspects of Nicholas Sandmann's claim. So comment section? No, that's too fast for a slow clap. Comment section?
Look, you can't just start a slow clap at any old time. You gotta wait for the right moment.
But how am I gonna know when it's the right moment?
Oh, you'll know.
Let's first start by reading the judgment on Nicholas Sandmann's motion for reconsideration. Actually, you know what? Scratch that. For first, if you haven't seen the previous videos, go watch them first. It might take upwards of an hour, but it will be well worth it. And now, let's read the actual judgment granting Nicholas Sandmann's motion in reconsideration. In the United States District Court for the Eastern District of Kentucky, Northern Division at Covington. Nicholas Sandmann versus the Washington Post. This matter is before the court on the motion of the plaintiff for relief from judgment under Rule 60, reconsideration of the court's previous order granting defendant's motion to dismiss under Rule 59, and for leave to amend the complaint. A proposed first amended complaint has been tendered, defendant has opposed this motion, and plaintiff filed a reply. So this is the procedural backdrop to the order that has been rendered. We don't need to get into all of it except for two specific things. Recall that the Washington Post's motion to dismiss was a motion to dismiss with prejudice, meaning that the plaintiff would not be allowed to refile on the same basis for a similar cause of action. And recall that the Washington Post's motion to dismiss was granted, meaning that it was granted with prejudice, meaning that the plaintiff could not refile on a similar claim. And so what seems to have happened here, along with the motion for review and the motion for reconsideration, the plaintiff, Nicholas Sandmann, also had to make a motion for permission to amend. The lawsuit having been dismissed with prejudice, the plaintiff could not amend the lawsuit to strengthen certain allegations or to respond to what served as the basis of the motion to dismiss. And so as to amend the original statement of claim to respond to certain weaknesses in drafting that might have supported or justified a motion to dismiss, plaintiff had to make a motion for permission to amend and submit the proposed First Amendment, and the judge had to grant that motion and accept the amended statement of claim. And that seems to be what has happened. The court heard oral arguments on this motion on October 16, 2019. Federal Rule of Civil Procedure 15A2 states that the court should freely give leave to amend when justice so requires. Denial of leave to amend is disfavored, and a district judge should grant leave, absent of substantial reasons to deny. Now this seems quite intuitive and it's almost a little surprising to me. In Quebec, normally speaking, you can amend your proceedings as often as you want. It's only if the amendment is opposed by the opposing party that you then have to make a motion for permission to amend. And if the amendments are contested, it's only in the most extreme circumstances that the amendments will not be allowed, those extreme circumstances being ridiculous procedural delays, calling in a new defendant once a trial has started, things that would result in an apparent injustice. Otherwise, the amendments will be allowed and the parties will be allowed to re-examine or respond to or do whatever they need to respond to those amendments. And we can see under the law of Kentucky, the spirit seems to be the same and amendments ought to be allowed unless there is a really good reason to deny them. In the interest of moving this matter along, the court will not set forth here a detailed analysis of the proposed amended complaint, which is lengthy and highly detailed. The court first notes that the statements alleged by plaintiff to be defamatory have not changed in the proposed first amended complaint. They are the same 33 statements alleged in the original complaint and set forth in the chart attached to the court's July 26, 2019 opinion and order. The court will adhere to its previous rulings as they pertain to these statements, except statements 10, 11, and 33, to the extent that these three statements state that plaintiff, quote, blocked Nathan Phillips and, quote, would not allow him to retreat. Suffice to say that the court has given this material careful review and concludes that, quote, justice requires that discovery be had regarding these statements and their context. The court will then consider them anew on summary judgment. What seems to be happening right now is the judge is saying you can proceed to depositions, examinations, discoveries, whatever you want to call it, on those three specific allegations, and the judge will consider anew on a summary motion to dismiss whether or not there is a failure to state a claim on the amended statement of claim. But let's now go back to the judge's order granting the motion to dismiss and look at those statements 10, 11, and 33. 10. It was getting ugly and I was thinking I've got to find myself an exit out of this situation and finish my song at the Lincoln Memorial, Phillips recalled. I started going that way and that guy in the hat stood in my way and we were at an impasse. He just blocked my way and wouldn't allow me to retreat. And the judge had originally concluded that this was, quote, not about Sandmann. What constitutes ugly and blocked are both subjective matters of opinion and that they're not defamatory. 11. A few of the young people chanted, build that wall, the man said, adding that a teen shown smirking at him in the video was blocking him from moving. And the judge originally came to the conclusion that this was not about Sandmann. What constitutes smirking and blocking are matters of opinion, and that it was not defamatory. 33. Phillips, who fought in the Vietnam War, says in an interview, I started going that way, and that guy in the hat stood in my way, and we were at an impasse. He just blocked my way and wouldn't allow me to retreat. And the judge concluded that it was not about Sandmann, that it was a matter of opinion, and that it was not defamatory. And I expressed my shock in the vlog dissecting the judge's dismissal of the suit. And I said that it would be up to a jury to determine whether or not this statement was about Nicholas Sandmann. I said it would be up to a jury to determine whether or not this was a matter of opinion or a statement of fact. I said it would be up to a jury to determine whether or not these statements were defamatory. And it seems that upon further reconsideration and in light of what appears to be the amended statement of claim filed by Nicholas Sandmann, the judge now concedes that this maybe was not up to him to decide at that stage of the proceedings. The court also notes that the proposed first amended complaint makes specific allegations concerning the state of mind of Phillips, the principal source of these statements, and that he had an unsavory reputation which, but for the defendant's negligence or malice, would have alerted defendant to this fact. And this, as far as I'm concerned, is the most important part of the order and one for which I think the comment section should take credit. And there's a big part of me that wants to believe that my video on the subject somehow got to Sandmann's attorneys, and that Sandmann's attorneys read through the comment section and realized where there were certain apparent weaknesses in the drafting of the original statement of claim. The proposed first amended complaint also alleges that plaintiff could be identified as the subject of defendant's publications by reasons of certain photographs of plaintiff and the videos. This should also be the subject of proof. And let's read this footnote too because it is relevant. The court notes that defendant has acknowledged that the blocking statement concerned plaintiff. That's a pretty big admission in light of the original judgment, which stated that the statements were not of and about Nicholas Sandmann. And from some reports, which I haven't been able to independently verify, apparently the video of the incident was not submitted as evidence in the original statement of claim, but I'm not sure if this is in fact 100% accurate. Suffice to say, what we can tell from this judgment is that the amended statement of claim makes specific reference to the fact that Nicholas Sandmann was identifiable, specifically because he was featured in the photograph of that article. That is what a number of you were saying in the comment section. Those comments got hundreds of thumbs up, and I like to believe that Sandmann's attorneys saw those comments and made the required changes. Of course, these allegations will be the subject of discovery and summary judgment practice. However, they do pass the requirement of plausibility. Therefore, the court being advised, it is ordered that 1. The motion of plaintiff for relief from judgment under Rule 60, reconsideration of the court's previous order granting defendant's motion to dismiss under Rule 59, and for leave to amend the complaint, be and is hereby granted in part and denied in part, consistent with the above discussion. Granted in part and denied in part. Nobody is totally right, nobody is totally wrong, everybody saves face, and Nicholas Sandmann will get some justice at the end of the day. Even if he doesn't win on the merits, at the very least, he's going to get a day in court. And most importantly, I am 100% vindicated. I am now batting 100% on YouTube law predictions. 2. The judgment previously entered herein be and is hereby set aside
and held for naught.
3. The proposed first amended complaint shall be deemed filed concurrently herewith. I'll get my hands on that statement of claim sooner than later so we can break it down, but I suspect it's going to be by and large the same, except it's going to have a number of additional allegations that probably ought to have been included in the original statement of claim. I'm not saying that to be critical, and there is no but. Hindsight is always 20/20. It's always easy to learn from your mistakes. And it is certainly only in looking back on a statement of claim that has been dismissed that one can learn what they ought to have alleged in order to prevent the dismissal. 4. Pursuant to federal rules of civil procedure, a scheduling conference is hereby set for Tuesday, December 3rd, 2019 at 1 o'clock. Yada yada yada, let's get to the important parts. The court will, inter alia, set discovery deadlines at this conference, resolve any anticipated issues regarding discovery to the extent possible, and set a deadline for the filing of motions for summary judgment. The scheduling conference will also serve as a preliminary pretrial conference which will address the following. Will the defendant seek to file a third-party complaint against the other media entities or individuals who are alleged to have defamed plaintiff? Should the cases now pending or to be filed later arising out of the same event be consolidated as contemplated by... I don't know what that is, and it doesn't really matter. The idea here is, should all of these claims be lumped together because they're going to call the same witnesses, same questions of law, same questions of fact, and should they all be heard together for expediency and maximum cost efficiency? Is the court required to order the joinder of any parties under federal rules civil procedure? D. The applicability with regard to punitive damages of Exxon Shipping Company versus Baker, and some other judgments, this 28th day of October 2019. And I want you all to appreciate that I am shooting this video on October 29th, 2019, because it is that important to respond to this immediately.
Because of vindication.
And that is the vlog, to be continued, of course, because this saga is going to go on for a while, and I'm going to be following it to the very end. And while I'm happy and optimistic that justice seems to have been served in that Nicholas Sandmann can at least proceed a little further with his case, I'm a little less optimistic as to my prediction as to what's going to happen on the merits given what has happened to date, but at the very least, the matter can proceed and people are not going to be left with the taste of injustice in their mouth. And if you like my videos and you like my channel, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below, merch links are all down below, and now you know your vlog. Peace out. Booyah!